in Planning and Performance at the New York State Department of Public Service. I have been designated to serve as the alternate representing the chair of the New York State Board on Electric Generation Siting and the Environment, or as it is also known, the Siting Board. I call this meeting of the Siting Board to order. Before moving to the agenda, I would like to introduce the alternates representing the permanent members of the Siting Board. When I call your name, please confirm that you are present. Kevin Malone, alternate representing the Commissioner of the Department of Health.
Present.
Mark Sanza, alternate representing the Commissioner of the Department of Environmental Conservation.
Present.
Vincent Ravishir, alternate representing the Commissioner of the New York State Department of Economic Development.
Present.
And John Williams, alternate representing the Chair of the New York State Energy Research and Development Authority.
Present.
Secretary Phillips, are there any changes to the agenda?
There are no changes to the agenda.
Thank you. We will begin with case 15-F-0122, application of Barron Winds LLC for a certificate of environmental compatibility and public need pursuant to Article 10 to construct a wind energy facility. Presented by Norina Chowdhury, Deputy Managing Attorney in the Office of General Counsel, Department of Public Service. Robert Rosenthal, General Counsel, and Jason Zaire, Chief, Environmental Certification and Compliance, Office of Renewable Energy Siting and Electric Transmission, Department of Public Service, are available for questions. Ms. Chowdhury, please begin.
Good afternoon, Chair Designee Mitchell and members of the Siting Board. I am presenting to you a draft order on rehearing arising from a petition filed by the town of Fremont located in Steuben County, challenging the Siting Board's action of July 2024 in the Siting Board's Article 10 case number 15F0122 Barron Winds. The Barron Winds project has a fairly extensive history. Briefly, Barron initially sought an Article 10 Certificate of Environmental Compatibility and Public Need by filing its Public Involvement Program Plan in February 2015 and its application for a certificate in November 2017. The Siting Board granted Barron a certificate in September 2019 after a fully litigated hearing process, including the issuance of a May 2019 recommended decision. The Siting Board's 2019 certificate allowed for the construction and operation of an industrial wind generating facility consisting of up to 68 wind turbines at a height of 500 feet and with a maximum nameplate generating capacity of 242 megawatts in the towns of Cohocton, Dansville, Wayland, and rehearing petitioner Fremont. In March 2020, Barron first sought an amendment to its certificate in which Barron sought to, among other things, increase the maximum height of its turbines located in the towns of Cohocton, Dansville, and Wayland to 650 feet, and noted that the Barron Winds project would be divided into two phases, with those turbines located in Cohocton, Dansville, and Wayland being constructed as Phase 1. The Siting Board granted Amendment 1 in May 2020, and construction of Phase 1 began in October 2021. In September 2022, Barron submitted a second amendment request accompanied by its plan to create a second company named Barron 2 to own and operate the Phase 2 portion of the Barron Winds project. To accomplish such ownership, Barron also filed a request to transfer the portion of its 2019 certificate related to Phase 2 to Barron 2. Barron's transfer petition and amendment petition 2 were consolidated for consideration for administrative ease and the conservation of party resources. Barron's Amendment 2 petition sought to increase the maximum height of the turbines located in Fremont to 650 feet, but also sought the Siting Board's waiver of Fremont's local law, which restricted the maximum height to 500 feet, so that the board could approve the requested increase of the 2019 certificate's maximum height. Because of the need for a local law waiver and other considerations, the Phase 2 amendment petition was deemed a revision under the Siting Board's regulations that required a hearing process. An evidentiary hearing was held in June 2023. After review of the compiled record evidence, the Siting Board conditionally approved both the Phase 2 amendment petition and the partial transfer in July 2024. Fremont petitioned for rehearing. As detailed in the draft order before you, Fremont sought rehearing for both the grant of the transfer as well as the Phase 2 amendment. Regarding the transfer, Fremont claims that the board's allowance of a transfer on the filing of certain agreements or other demonstrations denies it an opportunity to challenge such new documentation in a hearing. As the order explains, no legal error occurred inasmuch as the transfer of a certificate does not require any hearing, but only that the public be provided notice and an opportunity to comment on any transfer request. As Fremont will have the same rights afforded to it in the compliance process, there is no legal error. As to the substantive determinations, Fremont's objections can be distilled down to its allegation that the Siting Board made an error of law by finding that for certain finding sections, the Phase 2 amendment order found that despite the lack of certain evidence in the record, Barron was entitled to amendment of its 2019 certificate. Fremont, however, misapprehends the legal effect of the Siting Board's findings with regard to the sufficiency of the evidence presented. The Siting Board's evidentiary observations were not an indication that Barron was not entitled to any amendment, but that the evidence was unclear that the amendment could be granted without the addition of certain conditions to ensure that the impacts of granting the amendment were minimized to the maximum extent practicable. As such, the Siting Board's action granting the Phase 2 amendment was no different than any other conditional certificate or conditional amendment grant that the Siting Board has previously made under Article 10. The Board's July 2024 order is clear that only with the conditions added to the certificate, including the filing of updated or new information in compliance, would the order satisfy the requisite maximum extent practicable standard, and in that, on satisfaction of those conditions, the amendment was permissible and warranted. The town also claims that the Siting Board's grant of Amendment 2 was legal error and that it allowed two conflicting maximum generating capacity limits that in combination exceeded the allowed Project 2019 certificate limit. The draft order explains that the overall project capacity limit established in the original Article 10 certificate is the control, and the individual phase limits are subject to the overall project limit. The draft order clarifies one point of the July 2024 Phase 2 amendment order. In that order, the Siting Board, when considering the town's local law impact on setbacks, stated that a 1,500-foot setback from all non-participating property lines is sufficiently protective of local interests, which contrasts with the local law's 1,500-foot setback from non-participating residences. The draft order clarifies that the July 2024 order was not intended to be more restrictive than the local law. Finally, Fremont challenges the Siting Board's waiver of its local law height restriction of 500 feet, alleging that the board was in error where it determined that the waiver was warranted as being unduly burdensome in light of existing technology. Fremont claims that the waiver conflicts with the Phase 2 amendment order statement that neither the efficiency of a turbine model or its qualifications for tax credit make its compliance with Fremont's law technically impossible, impracticable, or otherwise unreasonable. However, Fremont misunderstands the significance of that statement, which is that the waiver is expressly not being found on those considerations, but is instead grounded in the record evidence that other considerations served as the basis for the Siting Board's finding of unduly burdensome. As noted in the draft order, those considerations included that only 3 turbine models exist that could comply with Fremont's local law. The use of any of those models creates significantly increased environmental impacts. And it was not simply that the shorter turbines would simply be less efficient, but that the difference in efficiency was such that without the waiver, the attainment of state policy goals that the project was intended to support would be severely impacted. As such, the Phase 2 amendment order found that Fremont's height restriction was unreasonable in light of existing technology that facilitated those same state policy objectives. That concludes my presentation, and we are available for any questions.
Thank you for that comprehensive presentation. I have no questions or comments. Let me turn to my fellow board members for any comments or questions. Mr. Malone.
No questions or comments.
Mr. Sanza.
No questions or comments.
Mr. Ravishir.
No questions or comments.
Mr. Williams.
No questions or comments.
I will now call for a vote. My own vote is in favor of the recommendations as described. Mr. Malone, how do you vote?
I vote in favor.
Mr. Sanza.
In favor?
Mr. Ravishir.
In favor.
Mr. Williams.
In favor.
The order is approved and the recommendations therein are adopted. Secretary Phillips, is there anything further to come before us today?
There is nothing further.
We are adjourned.